Ladies and gentlemen, dear colleagues, as George already mentioned, my presentation is going to be a bit wider than the title of our conference, as I would like to address those gender-based human rights violations which are often defended or legitimized by referring to cultural particularities in a given society. I try to make the intellectual and political complexity of the problem visible through a few concrete examples and suggesting practical solutions at the end. Let me start by highlighting a few important aspects of the universalism versus cultural relativism debate, launched in its modern form at the time of the adoption of the Universal Declaration of Human Rights. Many scholars in 1947 were of the view that any generalized human rights regime may encounter cultural differences, and because of that, the American Anthropological Society cautioned the UN Commission on Human Rights about this danger during the drafting of the Universal Declaration. In their statement of human rights, they stated, and I quote, "Values and standards are relative to the culture from which they derive," unquote. In this context, it should be mentioned that out of the 58 countries which drafted the UN Universal Declaration of Human Rights, 20 were from Latin America, besides 4 Africans and 14 Asian states. This means that only 20 states belong to the European and Western world. And non-Western states had a quite significant impact on some rights, mainly on economic, social, and cultural rights, but several rights, like the protection of minorities or the right to self-determination, were also raised by them, although they didn't make their way into the declaration, but subsequently they were accepted by international law. The proponents of strict universality are of the view that the human rights guaranteed in international treaties and conventions should be applied in all countries, and then they must prevail even when they conflict with established cultural and religious practices. This notion is based upon the equality, indivisibility, and universality of all human rights. In contrast, the advocates of cultural relativism argue that permitting international norms to override the dictates of culture and religion is a violation of state sovereignty. According to Makao Mutua, one of the most prominent representatives of cultural relativism, the entire human rights corpus should be debated and restructured with the participation of all societies and cultures. He indicated a few measures which could serve the better acceptance of the present human rights corpus by other non-Western societies. These are better balancing between individual and group rights, giving more substance to social and economic rights, relating rights to duties, or addressing the relationship between the human rights corpus and economic systems. In his view, the West has imposed its human rights philosophy on the rest of the world, and the rights guaranteed by the human rights corpus require, in fact, a Western liberal democracy. He goes even further by stating that the question of human rights is used by the West as a foreign policy tool against non-Western states. For example, when development assistance linked with the intention to civilize the concerned developing countries. Contrary to this opinion, Jack Donnelly emphasized that although human rights developed first in the West, it was not due to any particular features of Western culture, which is today a result and not a cause of human rights ideas and practices. In this context, he noted that the egalitarian readings of Christian ideas were repressed in the name of Christianity throughout almost all the Christian history. Consequently, no culture is by nature either compatible or incompatible with human rights. It is important to highlight that in the 50s, cultural relativist language was mainly used by Western colonial powers who resisted extending human rights to their colonies, which are, and I quote, at the lower stage of development, unquote. During the negotiations of UNGA Resolution 843 of 1954 on the status of women in private law, there were non-Western states who were in the front line to eradicate harmful customs and cultural practices to women. The rise of cultural relativism in the Third World was clearly associated with the rise of dictatorships in the 60s and 70s. The most important similarity between states referring to cultural relativism at that time was not the culture they represented, but the authoritarian character of their governments. They all shared a common fear of outside investigation and loss of power. However, in most of the cases of cultural relativism, the discussion is not about the denial of certain rights. It is more about the different implementation of human rights because of cultural differences. With the exception of the extreme position of strict cultural relativists, fundamental human rights are considered universal and cannot be set aside because of cultural differences. However, due to the different cultural context, the application of the same human rights standard in different situations can have differing results. A classic example for this is when a politician in the Western world would be accused of polygamy, and quite likely he could get a court order to restrict the publication of such information in a newspaper as a permissible restriction of information that is damageable to one's reputation. It wouldn't be the case if the politician would live in a country where polygamy is accepted in the social, moral, and legal context of the country, as the story wouldn't be considered defamatory. By this example, we have reached the examination of the status and situation of women, which, as we know, has been a disadvantaged one throughout history due to dominant patriarchal relations, irrespective of the culture they were living in. One of the main reasons why concerns and issues related to women were traditionally relegated to the private sphere, contrary to questions belonging to the public sphere, which were regulated and scrutinized by the states and were not only governed by cultural values and traditions. As a result, certain societies continued to defend their unequal treatment of women in the name of preserving certain cultural particularities. Consequently, as it was wisely argued by Arati Rao, and I quote, "No social group has suffered greater violation of its human rights in the name of culture than women," unquote. An interesting research was carried out by Gayatri Patel regarding the recommendations concerning women's rights during the first cycle of the UN Universal Periodic Review, the only truly global human rights review we have today. The importance and the sensitive nature of women's rights was clearly demonstrated by the fact that 3,702 recommendations by 84% of acceptance were formulated in this field, representing 17% of all the recommendations made during the UPR process, which made it the most frequently raised issues during the whole UPR. She differentiated several subcategories like female genital mutilation, abortion, access to health, polygamy, inheritance, forced and early marriage, honor killing, marital rape, and domestic violence. Her research demonstrated that when the observer states took a strict universalist position during the UPR by asking the concerned government to eliminate the practice and the related cultural norms, the answers were usually defensive and not substantial. According to Patel, the challenges to the normative universalism were made on two grounds: on the ground of national sovereignty and on the basis of the strict cultural relativist approach. For example, concerning the recommendations on polygamy, Burkina Faso, Chile, Tanzania, Ghana, and Libya used religious and cultural norms as a justification of this practice. Regarding the female genital mutilation, Mali and Liberia mentioned that this practice was deeply embedded in culture, and therefore they cannot accept the reforms suggested by the observer states. One of the most important findings of her research was that when states adopted a strict universalist or a strict cultural relativist position, the discussion has been oversimplified, as both approaches interpret culture as a static, homogeneous, and bounded entity which cannot be influenced by external norms or beliefs. However, during the discussion on female genital mutilation, forced and early marriage, domestic violence, and honor killing, both observer states and states under review recognize the relationship between women's rights and culture, and they appreciated reforms aimed at discouraging the cultural attitudes toward the practice, which are inconsistent with international human rights norms. This moderate cultural relativist position reflects a modern conceptualization of culture, which has porous boundaries and can be influenced by external norms and reformed over a period of time. The discussion on forms and early marriage, where many states adopted a moderate cultural relativist position, was more fruitful, for example, than the discussion on polygamy or inheritance, where states followed a strict cultural relativist position. In the context of cultural relativism and women's rights, we have to discuss the term harmful cultural practices. It means, according to Eva Brahms, practices considered harmful and disadvantageous by an outsider, but being meaningful to certain members of a given culture. In these cases, either the cultural insider doesn't perceive any harm or disadvantage, or it is justified and compensated for in a wider cultural context. These practices include, among other, female infanticide, child marriage, arranged or forced marriage, polygamy, or veiling. However, the lion's share of concerns by human rights groups is about female circumcision, which is considered as a female mutilation, in other words, which is described as a barbaric torture and mutilation intended to perpetuate male ownership over women. The first confirmation of this practice was the discovery of female mummies in Egypt from 484 BC. It can mean that it has originated in Egypt and spread it from there, although other researchers suggest that the female circumcision developed as an African tribal puberty rite and extended to places like Egypt afterwards. Consequently, its origin predate both Islam and Christianity. There is no reference to female circumcision in the Quran, and it is a mistaken belief that Islam religion requires this practice. According to the estimation of WHO, over 130 million girls and women have undergone some forms of female genital mutilation, and an additional 2 million girls are at risk annually. The explanations of the practice usually include several factors, like patriarchy, tradition, religion, myth, the importance of social cohesion in the maintenance of this right, sexual considerations, and economic concerns. One of the most important issues related to the cultural clash over female circumcision is about our culturally constructed lens, as it was described by Brad Billey. For example, the fact that the collective is having a higher status within the society than the individual is alien for most of us in Western societies. Without knowing much about the cultural relevance of female circumcision, like the importance of a girl entering womanhood, it is difficult to make an objective assessment about the practice. The most common measure suggested by those concerned with eliminating this practice is through legislation. Although this has often been implemented by governments in an attempt to show their seriousness and determination about the issue towards the West, it is evident that in many occasions the problem was not solved by the law itself. An alternative way of addressing the concern is by adopting educational programs which will encourage a positive trajectory towards eradication of the practice in the long run. The middle ground solution suggested by Brad Billey is to legalize the mildest form of female circumcision, together with an educational campaign focusing mainly on the health consequences of the more severe forms of the practice, as well as providing information for the local population how to more safely perform this practice. A third suggested step by him was to encourage international financial institutions to increase assistance to those countries most affected by this practice. These programs could also contribute to increase the status of women within these cultures. Let me conclude by enumerating those factors which, according to Billey, can serve the cultural transformation we are aiming at. First, it's promoting cross-cultural universals, uniting different cultures. Second, the recognition of the fact that the cultural development occurs through evolutionary and not revolutionary means. Third, gradualism opposed to abolition. Fourth, the importance of the participation of indigenous internal forces in the gradual process. Fifth, the functions of a given cultural practice should be taken into account, and functional substitutes are needed for the displacement of an undesirable practice. Sixth, the power of ethnocentric forces in a society should be acknowledged. Seventh, the presence of patriarchy should be incorporated into the realization. Eighth, the evolution of how women have historically been oppressed. Ninth, the importance of economic empowerment as a common denominator of all these cultural practices. And tenth, the positive impact of educational programs. So dear colleagues, it's my sincere hope that by this short presentation I could only highlight some part of this interesting and vitally important dilemma regarding cultural relativism in the field of women's rights, managed to indicate the complexity of this problem, and may contribute to the recalibration of our culturally constructed lens through which we look at all the developments of the world. And as it has been suggested in my presentation, there are no quick fixes available for these culturally sensitive problems, and there is a need for a constructive dialogue between the representatives of universalism and cultural relativism aimed at the gradual solutions which would be sustainable as they were discussed and accepted by the concerned local communities as well. History clearly demonstrated that forced arrangements never work and they are not for a long term. Thank you very much for your kind attention.